the CMA guidance specifically for weddings has now been published. Now, as ever, needs to be stressed, this is guidance, but they have said these are the basis that they would be looking at any enforcement that they take, and also is the direction they would expect courts to go in on any decisions around weddings. So this is there to really help businesses be able to move forward in negotiating with their couples and getting things sorted now. So the highlights. They are treating weddings right to the end of September as being under the same restrictions as lockdown, because the assumption was that there was going to be no real normality, no chance of normality before the 1st of October. So any contracts from those original disruptions in March right through to the end of September would be treated as frustrated in most cases. And that will mean then that null and void, and in most cases that would mean that no refund is due. However, they have then set out quite a lot of detailed situations where that will help businesses work out whether they can justify a refund. It's not for the couple to ask for that any deductions or suggest that there should be deductions on the refund. The default is that it should be a full refund unless the business can justify otherwise. So the sort of situations that the business will be looking at, the CMA specify that if the customer has received a benefit, then deductions can be made accordingly. So for example, if you have supplied a dress that they can reuse for another wedding or has a resale value, as opposed to the cost of catering, where the wedding was cancelled and couldn't go ahead and the couple had no benefit from that at all. So the two treated very, very differently in the CMA's opinion. The really important one, and they have hinted at this all the way along, this can only be recovery of actual costs that are specific to that wedding. It cannot cover maintenance, ongoing costs, business rates, the running cost of the business. It has to only be very specifically things that are accountable specifically to that wedding. What is going to be a little bit of a surprise to many is they have then gone on to say that even having worked out what that cost is and be able to quantify exactly what the cost is, what the losses are to your business as a result of that frustrated contract, that they feel that the courts will consider it fair that that cost is split 50-50 between the business and the couple, so you would still only recover half of that cost. That is what they are considering to be fair, and I think that is going to be very, very controversial. They do go on to explain the reason is that both businesses and couples have been incredibly unlucky by being caught up in this pandemic. Both should bear the losses equally, and they're also taking into consideration the fact that businesses will have the ability to recover that cost from future weddings. Again, that is going to be quite controversial, but this is the CMA guidance, so it is worth heeding it. Now, that is for frustrated contracts of anything up to the 30th of September would be treated as such. Obviously, there is always the option there to arrange for a wedding to be postponed, and they are very, very happy for such arrangements to be in place as long as the couple wasn't misled into believing that that was their only option. You can offer incentives for them to postpone, but you do need to make sure it was clear that they could, they did have the right to a refund, For weddings after the 30th of September that are going to be under restrictions, it gets a little bit more complicated. It depends on how significant the restrictions are. They consider that there are three key elements to a wedding: the venue, the catering, and also the reception, including the entertainment options. If any of those three key elements can't take place safely within the guidelines, and this is within the guidelines, not within the law, then that contract can be considered to be frustrated. So that's going to affect a lot of weddings where the couple may feel that the evening reception was a very important part of that contract. In that situation, if If it can't go ahead, obviously it's treated as a frustrated contract in exactly the same way. The default is that no refund is due unless there have been costs incurred. If it does go ahead, the CMA are advising that there must be, or should be, a pro rata reduction for the costs or the benefits that the couple are not receiving. And the reason for that is they feel that the business will be in breach of contract by not supplying that full service as contracted. And as such, they would be open to a claim for damages after the wedding if they go ahead, charge full price, but only supplied part of the service. So bear that in mind. It is worth, if that's lower numbers, or it means it's only one photographer there rather than two, or you're there for less time, whatever the change is, just think about a pro rata reduction. In the situations where a couple decides to cancel, for example, if the wedding's not going to be significantly impacted, but they still decide that they don't want to go ahead, the CMA have again just reiterated that the original terms must be fair when they relate to that cancellation charge. So they don't believe in non-refundable deposits. Any deductions in case of those cancellations should be taking into consideration any savings that the business will have in not having to deliver that service, the actual cost of the losses incurred by the business. So this isn't loss of profit, this is the actual losses that have already been incurred, not will be incurred in the future. And also the taking into consideration the fact that if the wedding had gone ahead, the couple would have been entitled to a pro rata reduction already because of the restrictions. So that needs to be factored in as well. So hopefully that guidance is helpful. It is worth reading the full article. We've linked to it. And hopefully it's certainly, this isn't the news any business was hoping for. This, as we suspected all along, has come very, very weighted in favour of the consumer. But hopefully, if nothing else, this is going to help businesses now save some time, save some anxiety in these disputes from having this much, much clearer guidance from the CMA in the direction they feel businesses should be going and the courts will be going. I hope that's been helpful.